Did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir. Could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things.
Representative Brandon Gill thought he had Jack Smith cornered. The freshman Republican from Texas walked into that House Judiciary Committee hearing with what he believed was a smoking gun, proof that the former special counsel had violated the Constitution by secretly obtaining Kevin McCarthy's phone records. Gill had his talking points memorized, his outrage dialed up to maximum, and his conclusion already decided. Jack Smith was a rogue prosecutor who had weaponized the Justice Department against Republicans. There was just one problem. Gill either didn't understand the law he was citing or he was counting on the American people not understanding it. And for the next 5 minutes of congressional theater, the world got to watch a freshman congressman confidently accuse a career prosecutor of crimes that don't actually exist. Let's break down exactly what happened in that hearing room, because if this exchange made you angry, you need to understand why, and it might not be for the reason Gill wants. The confrontation began with Gill establishing the basic facts. In January 2023, Jack Smith's team had subpoenaed the toll records of then-Speaker Kevin McCarthy. These records covered the period between November 2020 and January 2021, the critical weeks leading up to and immediately following the January 6th Capitol attack. The subpoena was issued 16 days after McCarthy was sworn in as Speaker. Already, Gill was framing this as scandalous. 16 days after becoming the highest-ranking Republican in the House of Representatives, you subpoenaed his toll records, Gill declared, as if the timing itself was evidence of wrongdoing. But here's what Gill didn't mention. The timing of McCarthy's speakership had absolutely nothing to do with the investigation. The period being investigated was November 2020 to January 2021, over 2 years before McCarthy became Speaker. The subpoena wasn't targeting McCarthy as Speaker, it was investigating McCarthy as a potential witness or participant in events surrounding January 6th. Smith tried to clarify this basic fact. Those two things had nothing to do with each other, he began before Gill cut him off. The congressman wasn't interested in clarification, he was interested in creating a clip. Gill moved to his main argument, the speech or debate clause. This constitutional provision protects members of Congress from being questioned about their legislative activities. It's designed to prevent the executive branch from intimidating legislators or interfering with the legislative process. Do you agree that might reasonably be considered a violation of the speech or debate clause? Gill demanded. Smith's answer was direct, I do not. And he was right. The speech or debate clause protects legislative acts, speeches, debates, votes, committee work. It doesn't provide blanket immunity for all communications a member of Congress might make. If it did, a congressman could plan a bank robbery over the phone and claim constitutional protection because he's a legislator. The Supreme Court has been clear about this. The protection applies to legislative activities, not to potential criminal conspiracies, even if members of Congress are involved in those conspiracies. And investigating who Republican leadership was communicating with in the days surrounding an attack on the Capitol isn't harassment, it's basic law enforcement. But Gill's real outrage was reserved for the non-disclosure order. This is where he thought he had Smith trapped. You issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas, Gill said, his voice dripping with accusation. Was Speaker McCarthy a flight risk? When Smith said no, Gill pounced. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution. This was Gill's gotcha moment. The visual of a prosecutor labeling the Speaker of the House a flight risk sounds absurd, and that's exactly the reaction Gill was banking on. But here's what Gill either didn't know or deliberately chose not to explain. That's not how non-disclosure orders work. The authority for these orders comes from 18 U.S. Code Section 2705B, and according to the actual text of the law, a court shall grant a non-disclosure order if notifying the person would result in any of 5 specific consequences. Gill kept hammering on consequence number 2. flight from prosecution, but the statute lists 5 options and prosecutors routinely check multiple boxes when filing these forms. The other consequences include destruction of evidence, witness intimidation, and seriously jeopardizing an investigation. When prosecutors request these orders, they're not claiming that every single consequence applies to every single person being investigated. They're explaining to the court why secrecy is necessary for the investigation to succeed. In this case, the concern wasn't that Kevin McCarthy would flee to Mexico. The concern was that if McCarthy knew his records were being examined, evidence might disappear, witnesses might coordinate their stories, and the investigation would be compromised. Smith tried to explain this. The risks aren't necessarily associated with the subscriber to the phone, he said. They're risks to the investigation. But Gill wasn't having it. "This is not your time. This is my time," he said. He snapped, cutting Smith off mid-explanation. "And that tells you everything you need to know about what was happening here." Gill wasn't interested in understanding the law. He was interested in creating a narrative and allowing Smith to explain how non-disclosure orders actually work would undermine that narrative. Let's talk about what toll records actually are, because the word spying is doing an enormous amount of work in Gill's framing. Toll records are metadata. They show who called who, when, and for how long. They do not include the content of the calls. Federal investigators weren't listening to Kevin McCarthy's conversations. They weren't recording what he said. They were looking at a log of numbers that called his phone and numbers he called. This is standard investigative procedure. It's how law enforcement builds timelines and identifies potential witnesses. If you're investigating who was coordinating in the lead up to January 6th, you need to know who the key players were talking to. That's not spying, that's investigation. Gill also made a big deal about the fact that McCarthy and the American people weren't told about the subpoenas. "Nobody would know what you were doing," he said, as if this was evidence of a conspiracy. But again, that's how investigations work. Prosecutors don't announce their investigative steps in real time. They don't call suspects and say, "Hey, just wanted to let you know we're looking into your phone records. Hope you don't delete anything." If they did, every investigation would fail, evidence would vanish, witnesses would coordinate their stories, the entire process would be pointless. Imagine if the police had to ask a bank robber for permission before checking the security cameras. That sounds ridiculous because it is. Yet that's the standard Gill was demanding be applied to members of Congress. Gill's final attack centered on an email from a Justice Department attorney named John Keller. The email sent from the Public Integrity section to Smith's team discussed potential legal risks associated with obtaining congressional phone records. As you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause, the email stated. Gill waved this email around like it was proof of Smith's guilt. "You knew there was a risk you were violating the speech or debate clause," he declared triumphantly. But here's what Gill didn't read: the full context of that email. The last sentence stated, "Given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here." In other words, the Justice Department attorney wasn't saying they were violating the Constitution. He was saying there was a small risk that members of Congress might sue to block the investigation. But that risk was minimal because the investigation was proper and the members weren't being charged with crimes. That's not evidence of wrongdoing, that's evidence of lawyers doing their job, assessing legal risk and proceeding carefully within the boundaries of the law. Smith tried to explain this. "To be clear, this statement is not from my office, you know." Gill cut him off again. "This is your justification for those subpoenas." But it wasn't. It was a lawyer's assessment of litigation risk, which is completely different from justification. Every major law enforcement action involves lawyers evaluating whether someone might sue and what the likely outcome would be. That's called due diligence, not conspiracy. Gill concluded his questioning with a flourish. "You walked all over the Constitution throughout this entire process. You were spying on members of Congress and you know it. It's absolutely disgraceful." And with that, his time expired. So let's step back and analyze what actually happened here. Because if you're feeling outraged after watching that exchange, it's important to understand whether your outrage is directed at the right person. Jack Smith conducted an investigation into an attack on the United States Capitol. As part of that investigation, he obtained court-approved subpoenas for toll records, not call content, just metadata of people who might have information relevant to that attack. He followed Justice Department guidelines, consulted with ethics officials, and obtained judicial approval every step of the way. Brandon Gill, meanwhile, used his 5 minutes of congressional questioning to misrepresent how non-disclosure orders work, ignore the actual text of the statutes he was citing, cut off Smith's attempts to explain, and create the false impression that standard investigative procedures are constitutional violations. Here's the simple truth. If Jack Smith had told Kevin McCarthy he was examining his phone records, evidence would have disappeared. That's not speculation, that's how these things work. People delete texts, they coordinate stories, they can't recall convenient details. The non-disclosure order wasn't about treating McCarthy like a criminal, it was about preserving the integrity of an investigation into one of the most significant attacks on American democracy in modern history. And the idea that members of Congress should be above this kind of scrutiny is dangerous. It suggests that political power should grant immunity from investigation, which is fundamentally incompatible with the rule of law. The speech or debate clause doesn't mean that congressmen can participate in conspiracies and hide behind their office. It means they can't be questioned about their legislative work. Those are completely different things. If Kevin McCarthy was making phone calls as part of his legislative duties, calling other members to whip votes, for example, those calls would be protected. But if he was making calls as part of a coordination effort related to January 6th, those calls are not legislative acts. They're potential evidence in a criminal investigation. The Supreme Court has drawn this line clearly. Legislative activities are protected. Potential criminal activities are not, even if a legislator is involved. Gill knows this. Or if he doesn't, he shouldn't be questioning a former special counsel about constitutional law. Which means what we witnessed wasn't a good faith legal debate. It was performance art designed to create outrage among people who won't look up the actual statutes. And honestly, it's working. That clip is going viral in certain circles, with people convinced that Jack Smith violated the Constitution. They're convinced because Gill presented one side of the story with absolute confidence and didn't allow Smith to provide context or explanation. But here's what should concern you more than whether Jack Smith properly obtained toll records. What were those calls about? Gill wants you focused on the process, the paperwork, the non-disclosure orders, the timing. He wants you angry about the investigation so you forget to ask what the investigation uncovered. Because if those calls were completely innocent, if Republican leadership was just having normal political discussions, then releasing the records would vindicate them. The fact that they're fighting this hard to keep the records sealed suggests they contain something that someone doesn't want the public to see. Think about it. If you were under investigation and you were completely innocent, would you rather have the investigators follow proper procedures quietly, or would you want them cutting corners and violating your rights in ways that could get the evidence thrown out? The answer is obvious. You'd want them to do everything by the book because that makes the evidence airtight. The only reason to attack the process is if you can't attack the substance, and that's what Gill was doing. He couldn't argue that the investigation was unnecessary. January 6th happened. He couldn't argue that examining Republican leadership's communications was unreasonable. They were key players during the relevant period, so he attacked the paperwork. On a personal level, imagine if you or anyone you know were under investigation for a serious crime. You wouldn't get a courtesy call from law enforcement asking if it's okay to check your phone records. You'd get a knock on the door, probably early in the morning, and probably not a friendly one. The standard Gill is demanding for members of Congress: advance notice of investigations, public disclosure of subpoenas, multiple warnings before any investigative step, is a standard that applies to no one else in America. It's a level of privilege that places the political class above the law. On a broader scale, this is an attempt to criminalize investigation itself. By dragging Jack Smith before Congress and accusing him of constitutional violations for following standard procedures, Republicans are sending a message to every future prosecutor: don't investigate us or we'll investigate you. It's a chilling effect designed to make law enforcement think twice before pursuing cases involving powerful politicians. And if it works, it will fundamentally change the relationship between political power and legal accountability in America. The reality is that Jack Smith followed the law. He consulted with ethics officials. He obtained judicial approval. He worked within the framework that governs all federal investigations. Brandon Gill, meanwhile, used congressional immunity to make accusations he couldn't make anywhere else without facing defamation liability. And the American people deserve better than this performance. They deserve representatives who understand the law they're supposed to oversee, who engage with evidence honestly, and who don't waste taxpayer-funded time on theatrical outrage designed for social media clips. Before we end, here's the question worth asking. If examining phone records of people potentially involved in January 6th is spying and disgraceful, what does that say about January 6th itself? If the investigation is improper, are they arguing that January 6th shouldn't have been investigated at all? That attacks on the Capitol should just be ignored if members of Congress might be implicated, because that's where this logic leads. And it's a place no democracy can afford to go. The rule of law means everyone is subject